Well, good afternoon, everybody, and a very, very warm welcome to NE1's first webinar. Thank you for joining us. We're very fortunate this afternoon to be joined by Robert Gibson, who's a senior partner at Samuel Phillips' law firm in Newcastle. And you're joining us today for our first Q&A session around the government's coronavirus job retention scheme, also known as temporary leave or furlough. The latest guidance was issued, I think, about a couple of days ago, so we're very much looking forward to Robert's expertise in this area. He has been with Samuel Phillips for most of his professional career. He's been a partner for over 30 years and is a former managing partner of the firm as well, and senior partner for 3 years. And it's worth noting, I think, that as a partner, Robert is also an owner of the business. So he has first-hand experience as an employer of issues around furlough. So Robert, thank you very much. We're really looking forward to what you have to say. For those of you who are listening, and I don't think you can see each other, but we have representatives from retailers, from leisure operators, from hoteliers, from investment management organizations, from trainers and training organizations, and a variety of other professionals, including at least one dentist, accountants, and lawyers. So we will get into the swing just now. You will all notice at the bottom of your screen that there is a chat function. So that's what we'll use for you to ask Robert your questions. I'm going to ask the first couple of questions just to get us going. And then if we need to get a little bit more explanation from you as individuals, Nicole, who is sitting in the background, will unmute you. So you can be your voice can join us on our discussion. So Robert, before we get into the questions, could I just ask you, please, to tell us something around the background to the coronavirus job retention scheme, and perhaps a little bit about some of the pitfalls and things people should be watching out for first. Robert.
Good afternoon, everybody. I am delighted to be here. It's I suppose a novelty, as in it's 1 hour with a lawyer free of charge, which is unusual and welcome, I think. We're all of us experiencing, I guess, the ramifications of this horrible disease that is striking around the world. And coronavirus is part, or the job retention scheme is part of the government's response to the financial situation that's hit us all, as you all know. Effectively, interestingly, what the government did was it locked down part of the economy within entertainment, leisure, retail, but for the rest of the economy, it said effectively, permissively, carry on trading if you wish, try above all to work from home where you possibly can, and if you can't, well then you can go to work, but it has to be as safe as it can possibly be. They appreciated, by locking down part of the economy, that there was a range of measures they had to produce. Some of them have been good, some of them have been, frankly, not very good, if I'm honest with you. I think the coronavirus business interruption loan scheme has proved to be something of a damp squib, in that people can't get the loans from the banks, and the criteria for the loan appears to be it would have to be a valid loan but for coronavirus in the first place, which seems to be unhelpful. But I mean, you know, you've got measures like VAT deferral, you've got an equivalent for the self-employed, you've got grants for small businesses, you've got rate grants for businesses under a particular rateable value, and then really right in the middle of it all, and I guess the most important part of it is the job retention scheme, also known as furlough. And I mean, it really is the central, I think, plank of trying to protect jobs. And it's certainly by far the most important thing that we've had to advise about. I do daily vlogs, and almost every day we're talking about furlough and its ramifications. So all I'll say to everybody that's listening, please join in this hour's question and answer session. I'll do my best. There is literally no such thing as a daft question, merely a question. We all of us are looking for answers here, and you can bet your bottom dollar if you're thinking it, half the people listening are thinking it as well. So please join in, ask the questions. I'm here for an hour, and I certainly don't want to just sit here staring at people. So I'm good to go.
Brilliant. Robert, well, thank you very, very much indeed. If I ask I'll ask a couple of questions now. I'm not going to identify the questioners at this stage, but you'll recognise yourself. So if you've got some supplementary, then please use the chat, and we'll follow up on this. So the first one, and both of these come from independent traders. The first question: I have read and seen posts regarding the payment of furlough money only being paid if or when money is received, and no longer being able to claim if that is what the employer has done. Yet original posts on the government's website stated that employers could wait to pay the money out until the scheme had been set up. For a sole trader who is not entitled to any of the other grant or loan schemes in place, I have no means of paying wages, as I have no income and no means of getting further into debt. Assuming I've understood things correctly, does this mean I won't be able to claim now? And if so, what does that mean for my staff?
Okay. Firstly, what you need to have is an online PAYE real-time information scheme. So effectively, most employers now will pay their PAYE to the revenue through an online payment system. And that's known as RTI, real-time information. And so to qualify at all, you have to be on that scheme. Originally it was the 28th of February, but they've put that back to the 19th of March. So you have to be registered on that online scheme. And if you're not, you don't qualify. Secondly, effectively, you have to have employees who have been furloughed. And by that, it means the employee has been instructed by the employer to cease all work in relation to their employment. That instruction has to be given arising as a result of coronavirus or coronavirus disease. And the period for which the employee has ceased work or will have ceased work is 21 calendar days or more. As long as those conditions are met, then you are entitled to claim furlough pay. The fact that you haven't already paid it out doesn't matter, because the scheme that's gone or has been set up allows you to commit to, it allows you to claim a payment for earnings paid or reasonably expected to be paid by the employer. So if you haven't paid them, it doesn't matter as long as they're reasonably expected to be paid. So we expect on Monday a portal to open up. They've said that it's going to open up on Monday, 20th of April. You're going to have to register on that with various pieces of information. Assuming you do that, at that point, you will be able to submit your claim for your furloughed staff, and you are entitled to be reimbursed for those you have either A, paid, or B, who are reasonably expected to be paid.
Okay, Robert, thank you for that one. I can see that our chat section is already filling up with questions, so that's really good news. I'll read out the second question, and then we'll go to the questions that are coming through chat.
Sure.
So this is about if an employee who works different hours each month has taken some unpaid leave during the year 1920, do I calculate 80% of their pay based on an average of all 12 months? We have a number of employees working to the national minimum wage. When calculating average pay, should it be the 1920 year, or do we apply calculations to take into account national minimum wage increase? Similarly, if someone reaches their 21st birthday in this time, do we make an adjustment?
Okay. The directive that came out from the Treasury to HMRC calculates effectively remuneration in two ways. Firstly, it says if you're a fixed rate employee, in other words, your salary remains the same, then that's the basis of calculation. If you're not fixed rate, then what it says is this: it's the average monthly or daily amount paid to the employee for the period comprising the tax year 2019-20, or if less, the period of employment before the period of furlough began, or the actual amount paid to the employee in the corresponding calendar month in the previous year. And it's the greater of those. So you look at your average amount that you paid to the employee for the tax year 2019 or 20. If they haven't been employed for that period of time, then you look at however long they have been paid, or you look at the corresponding calendar period in the previous year if they were employed then, and it's the bigger of those two which is the average figure, and that's what you apply. As to the national minimum wage, it isn't relevant for people on furlough. National minimum wage only applies to those who are working, and those who are on furlough aren't working. So if your 80% takes you below the national minimum wage, so be it. That is permitted by the government. So for those with variable earnings, it's either calendar period in the previous year, or the average in the last tax year, or the average since they began employment. It pays you money.
Robert, thank you. It's I'm very conscious this is a complex area, isn't it? And actually, one of the points I was going to make at the end, just before we finished, was that everyone who's listening should consider taking their own professional advice on this, because there will be doubtless a number of pitfalls. It would be a great shame if people get it wrong at the beginning, because I'm sure it'll be hard to recover from later on. So it's well worth making sure you're completely squared away from the point of view of documentation you may need, and getting a professional to help with that. I'm sure.
Well, I would say that, wouldn't I? Would say that, of course, yeah. but genuinely, what's going to happen, I think, is that the revenue are going to pay out, but they've made it clear that you have to keep your records for 5 years, and they've also just made it clear that you need to have a written agreement between the employer and the employee to recover the money at all. And I think that the sums of money you're potentially talking about are quite significant. And if the revenue starts recouping that money subsequently, then it could cost you dear. And therefore, frankly, for a relatively modest amount now, you're protecting yourself against the revenue coming at you subsequently, and potentially taking, well, we can all of us calculate roughly what, say half your workforce has been furloughed or more. 3 months of their wages is quite a significant chunk of money, and I think that's what you're looking at. So yeah, take advice.
It's worth getting it right, isn't it?
Yeah.
I think, Robert, we'll turn to the chat questions, and I think what we will do, I mean, we are recording this so that people can look at it afterwards. I'm not entirely sure if the chat will appear on the recording, so I'll read these questions out as well. Yeah. What if an employee started in mid-March, but the real-time information wasn't submitted until the end of the month as normal? Is it right that they still aren't entitled to furlough?
Now, this is let me explain this one. I know exactly where they're coming from. The original scheme said to be eligible, you had to be on the real-time information form with the revenue as at the 28th of February. And only people on the form as at the 28th of February could qualify. And the government guidance was issued and the scheme came out, and there was quite a debate which arose because a lot of people were then recruited after the 28th of February and before the government announcement, which was on the 20th of March. You know, several 100,000 people fell into that area where they weren't going to be covered by the scheme. They'd been recruited after the 28th of February. They were not eligible, therefore, for furlough. Many were losing their jobs, or if they were being laid off, they weren't entitled, the employer wasn't going to get the money back. So the revenue at the last minute, in an attempt to help those people, said in the direction it gave to HMRC that actually they were moving the date of the 28th of February to the 18th of March, with the express intention of making those people recruited between 28th February and 18th March covered. Unfortunately, what they then did was they added in a provision, and it's 3.2 of the direction. It says the employer must have a pay-as-you-earn scheme registered on HMRC's real-time information system for PAYE on 19th March. So what the direction says is, in fact, your RTI form with the revenue as at the 19th of March is what counts. So if the individual is on that form, then they are eligible for furlough reimbursement. If they're not on that RTI form as at the 19th of March, then they're not eligible. And a lot of the people recruited after the 28th of February and before the 19th of March will not be on that form. Because employers don't immediately submit the form, it goes out monthly, usually around about the time the payroll goes out, and most people pay at the end of the month. So a lot of people recruited after the 28th of February and before the 19th of March won't be on a form registered with the revenue as at the 19th of March. And so, under the scheme, you can't claim. However, all of the government guidance up to this point has created the legitimate expectation that you will be able to claim. But the scheme as lodged doesn't permit it. And therefore, I think what I have to say is you're not eligible for those staff. But what you do have is a public body, the government, creating a legitimate expectation that they would be covered. And I'm afraid to say you're going to have to potentially take action to recover that money, but not under the scheme. So it'll be separate legal action, which is what you'll have to take to recover the money. Sorry, but there you are. It's one of those unforeseen, unfortunate consequences of people doing things at short notice at the last minute to try and help, but actually making it worse. So it's a very long answer for saying, if you're on the payroll, if you're not on that RTI form by the 19th of March, you don't qualify under the scheme. And what you'll have to do is take legal action separately to try and recover the government, to try and recover the money from the government.
Do you think, Robert, that there's any possibility, given, I suppose, anomalies like that, which, as you sort of said, were possibly not the government's intention, but that's a consequence, that actually there may yet be sort of further relaxation or further guidance that people can sort of hope for that might then improve the situation?
The answer to that is yes. I mean, what we have is you have Section 76 of the Coronavirus Act, which said that HMRC can run this scheme as the Treasury directs. The government then issued some guidance, and that's all it was, guidance, nothing more, nothing less, but it creates a legitimate expectation. The Treasury then issued its direction under the Act on the 15th of April, and that direction is supposed to be definitive. It's written in legalese, and it has the force of law, and I don't think they were intending to change it much. However, I think you're right, and this is one of those areas where the government will realise they've dropped a clanger, and it is to be hoped that there will be some corrective amendment issued. So I wouldn't say rush quickly to litigation, absolutely not. I would say, now just hang on a minute, maybe they will correct it. But I would also say if they haven't corrected it by the time we come out of lockdown, then they won't be correcting it. And that's the point at which I think you would have to take legal process separately.
Okay. Well, look, Claire, I hope that's been of some help. Let's take another question. So this is from Simon. I'm a seasonal employer in I'm running a water sports centre. We have employed the same member of staff from the end of February to the end of October for the last 2 seasons. Had a written contract in place for 2020 season, and they joined us on the 27th of February this year, 2020. He was paid until the end of March as normal, but was not on my RTI return for February payroll. Is he eligible?
If he's not on your RTI return form, no, you're not eligible. Although I do say 19th of March was the cut-off point. So if he was on the RTI form that they submitted on the 19th of March, then yes, he might be eligible. But if he isn't, no. It's one of the terms of the scheme. You've got to be on the form, and if you're not on the form, sorry, not eligible.
Okay. Let's go to the next question. Can an employer insist that a furloughed employee take leave whilst being furloughed? And that is around wanting to avoid a sort of mass number of holidays being taken by employees later in the year.
This one
might apply to lots of people.
Yeah. Well, firstly, the direction given by the Treasury to HMRC is utterly silent on the issue of holiday, as is government guidance. Absolutely silent. So that the strict legal answer to this question is we don't know. If you want my advice, and Lord knows that's why you're here now, I'll say this. I think holiday definitely accrues during furlough periods, in that the contract subsists and therefore holiday accrues. Secondly, if employees take holiday by agreement during that period, then that holiday pay should be at their normal holiday pay, not 80% furlough, but their normal holiday pay. Thirdly, it has been said that in the latest legislation that up to 4 weeks of holiday pay can be carried forward for the next 2 years. Finally, however, there is European legislation which says effectively you can require someone to take holiday if they won't, provided you can give twice as much notice as the holiday to be taken. So technically, I can say to you, I'm going to give you 10 days notice that you have to take 5 days holiday. And as long as it's part of your first 4 weeks holiday in the year, which is covered by the European legislation, then that will count as holiday, and therefore technically you can oblige the employee to take the holiday. The counter argument, and this is why we're being hesitant, the counter argument is the whole ethos of European legislation is that holiday is about, it's a social policy issue, and holiday is about rest, recovery, relaxation. And that can't take place, in a sense, if you're being forced against your wishes to take it at a time that isn't restful or recuperative to you. So, very long answer. This particular bunny thinks you can oblige them to take holiday. There is a counter argument. I suppose what I would say is, what's the downside? The downside is you force them to take holiday and somebody comes along afterwards and says, well, I don't think that was right. And they bring an action for restoration of holiday pay or holiday entitlement. And the worst that's going to happen, I think, is a tribunal will say, well, they're right, you're wrong. They can have an extra week's pay, or an extra week's holiday rather. An extra week's holiday rather than an extra week's pay. So I think it's a tricky one. I sit on the side of the fence, which is you can make them take the holiday, others don't. I don't think there's a huge downside if you actually insist that they should take it. And that, for me, is where I would go. I'd start, however, with trying to get them to agree it. It's always better to get people to agree things. But if you can't, I think you can.
Okay, Robert, thank you. There's a related annual leave question, which we might just go to as well before
Sure.
we go on to another one, which is, what is the situation with regards to annual leave? Can staff top up their furlough pay with annual leave pay? And has there been any guidance about what will happen after May?
Second question first. Guidance after May? No, there hasn't been any guidance. What we have is the Treasury Directive, which is 15th of April, and that's all we have on the job retention scheme, and it says nothing about holiday, full stop. In terms of holiday, in my view, yes, you should top up their furlough pay whilst they're on holiday to their normal, what would be holiday pay. ACAS guidance says exactly that. If someone's having holiday, agreed holiday that is with ACAS, if they're having holiday, you pay them their full pay. And that's fine, because the fact that you're topping up the furlough pay doesn't matter at all. That's what you're paying the employee. What you recoup, however, is the basic furlough pay of 80%, capped at 2,500.
Okay. Just looking at our list of questions, I'm about to ask Robert the last question that we've currently sort of got on the ticker tape, if you like. So, and then I've got one or two of my own. But I think if people who still would like to ask a question and haven't yet, now's the time to start typing, because I think if there are no further questions, I'm not going to keep Robert or any of us waiting. But the next question, so please ask away, but the next question then from Claire is, will the furlough claim period be the same as the payroll period?
Good question. Furlough is claimed in 3-week bites. So the minimum furlough period is 3 weeks. However, you are entitled to claim for pay that you've paid or expect to pay. So I think the actual furlough claim you submit should be for the regular pay period. And effectively, you submit your claim once a month to the revenue, and it's for the month. Some employers submit it on the 26th or the 27th or whenever. And really what you have to do is calculate for that month the furlough pay. And so if they went, for March, it'll be 12 days. For April, it's going to be all of April. So I would be saying you submit the claim for the month and you calculate the furlough entitlement during that period. So if it's expected to be 4 weeks, it's 4 weeks. If it's only going to be 3 weeks, it's 3 weeks.
Okay, Robert, thank you. One of my own, furlough has to be,
Hang on.
understand it.
Furlough
has to be, I suppose, actioned, if you like, with the member of staff's own agreement. What would happen if they don't agree? Is it as simple as the fact that they then don't be furloughed and something else has to happen?
Furlough has to be by consent. And under the new directive, it has to be an agreement in writing. And this, I think, will catch many. What it says is, an employee has been instructed by the employer to cease all work in relation to their employment only if the employer and employee have agreed in writing that the employee will cease all work. So it has to be an agreement. It absolutely has to be an agreement in writing. And so if what you've had in a number of cases is the employers called everybody together and said, well, look, I'm going to have to furlough you all, off you go, and confirmed it in writing, that's not good enough. You need a furlough agreement.
Agreement.
And if they don't agree, well, one of two things happens. One, they come into work and you pay them as normal if the work is there. Or two, they're in a redundancy situation and you take them down the redundancy route in the normal way of things. And so if there are sufficient that requires collective consultation to take place, 30 or more, or 20 or more, I can't remember, then you have to go down a collective consultation route. You have to have elected representatives. If there's fewer than that, it's a straightforward consultation with notice pay and redundancy. And of course, their notice pay is the full pay, not the furlough pay. And of course, you won't be able to recoup it. So that really is the situation. You have to have an agreement. It has to be in writing if you want to recover the furloughed money. If they won't agree, it's back to work or it's redundancy.
Okay. Robert, thank you. There are some more questions actually have come in whilst we've been talking. So from
Sure.
Paul, and I think you've partly answered this one already actually, but we'll just check. The minimum period of furlough, I understand, is 3 weeks. If the employer can see, for example, 1 week's work for an employee in 4 weeks each month, can an employee be brought in and out of furlough?
Yes. An employee, the only requirement is an employee is furloughed for a minimum of 3 weeks. That's the only requirement. So yes, you can bring an employee in and out of furlough. You can bring them in, well, frankly, for a day, a week, whatever. So yeah, if it suits your purposes to bring them in for a week and then furlough them for 3 weeks, you can do that. I think the only thing I would say is that suggests to me you've probably got some work for them, about a week's worth, but not 4 weeks. That's fine, as long as they work during the week and it doesn't spill into the furlough period. So furlough period, they're not doing anything for you. But yes, you can bring them in for a week, they work, you can furlough them for 3 weeks, and when you submit your furlough claim through the portal at the end of the month, you will claim for the 3 weeks.
Okay, Robert, thank you. And actually, I think Deborah, your question that should answer you as well. Claire, you have asked if you can claim back national insurance. Is this before or after employer allowance? Does annual payroll schemes still count? The scheme covers the whole year, but submission by the end of March. I think I've got that right. Robert, do you understand that?
I'm not sure I do.
What we might...
I can say that the government will pay the employer national insurance. Just bear with me. It's the employer national insurance rate on top of the 80% or £2,500. That's what they will pay. So yeah, here you are. Well, firstly, the government won't reimburse you more than the national insurance contributions you do pay. And under the regs, for the purposes of the scheme, the employer national insurance contributions are the secondary class 1 contributions an employer is liable to pay as a secondary contributor in respect of an employee. So I think that's what's covered.
I think yeah. What we might do, if we take, there's an interesting question from Lisa about maternity. Perhaps if we take that one, and then Claire, Nicole, who is from my office, who's sitting in the back of this. What we'll try to do is unlock your microphone if you're, and I'm afraid I'm hoping you're here. Right? No, you must be because you've asked the question. So we'll try and unlock your microphone, and then perhaps you and Robert can have a direct conversation about your national insurance related question. So we'll do that in the meantime. Robert, Lisa's question. I have someone due back from maternity in May. They would need to be furloughed. Can I do that?
Yes. Yes. When their maternity, firstly, you can furlough them when their maternity period ends. Yes, you can. You can also agree with them, if you so wish, to end their maternity period early and then furlough them at that point. And that means the individual might qualify for more pay than what would be their statutory maternity pay. It's one of the hidden benefits of the scheme. But certainly you can furlough them when they come back from maternity in May, and if they choose to come back early, with your permission, they can be then furloughed early.
Okay. Now, Claire, have we managed to unlock you?
Yeah, I think so. Can you hear me?
Yes, we can.
I can.
Excellent. Wow. So the question was essentially, if we've got employers where their national insurance payment in April would be covered by the employment allowance, so they would get a £4,000 credit towards the national insurance. If their national insurance would be covered by that allowance, can they claim that back from the government when they would use the allowance later in the year? Or is it only a cost for the actual company if the employment allowance doesn't cover the national insurance?
Now that is a belter. Firstly, the rules are quite clear. You can only claim national insurance on the reduced pay. So that's number one.
Yeah.
But number two, I don't think you can claim to be reimbursed that which you have not actually paid.
Okay.
I think the way that the rest of firstly, it's silent on that very point. So in answer to your question, it doesn't actually say,
Yeah.
but throughout the rest of it, what they talk about are where there are payments made by government to an individual, you can't have those payments and furlough. The whole ethos of the scheme is that the government isn't going to pay you twice.
Yeah.
So if you're getting a credit against national insurance contributions, then you can't claim from a separate government pot, in my view, that which you've already received from another one.
Okay.
However, I don't know whether the employment allowance is actually put against a specific period or not. I really don't.
If you could defer claiming it until later in the year.
Say again?
You could defer claiming the employment allowance until later in the year.
My instinct is yes, if that's permissible. You come back to if you're paying, you're entitled to claim national insurance on top of the 2,500 cap or the 80% of whatever you do pay.
Yeah.
And if you're paying that national insurance, you're entitled to it being reimbursed. If subsequently you get an allowance, well, so be it. You get a different allowance, as long as it can't be attributed to the period for which you're seeking reimbursement of the national insurance contributions, if you see what I mean. Does that make sense, Claire?
Yeah, that makes sense. Yeah.
Okay.
That's great.
That was a good one.
Thanks. Can I ask the annual payroll question as well?
Yeah, go on, shoot.
So if you've got, say, like a director-only payroll that's just run as an annual payroll, so we make the submission in March each year,
Oh,
but they're
really?
not technically on the payroll scheme, are they entitled to be furloughed?
Well, if you are on the RTI form, when it is submitted, And it has to, when is your form submitted? I hope it's by the 18th of March.
No, it's not. It's by the end of March.
Well, you would, oh gosh.
I mean, it's not my form. It's just a specific client. It's quite rare that we have an annual payroll. But
I mean, I haven't come across that in years.
Yeah, it's one we inherited from a different accountant, so it's not something we would normally do.
Yeah.
But it's just a little bit of a strange one.
I think you would have to go back to last year. Whatever payroll they had with the revenue as at the 18th of March 2020 is the one that counts. And I think if they're not on the form, they're not eligible.
Okay, thanks.
I suspect you as accountants may well have to make separate representations on the client's behalf to the revenue for the money for those employees who aren't covered. And good luck. Depends what sort of view they take.
Yeah, that makes sense. So thank you very much.
Yeah. Okay.
Well, thank you. Thank you very much indeed for your questions. We've got a couple of other, I think, quite interesting ones around directors being furloughed, and also a question about redundancy. So perhaps if we go, Simon, to your question, and you're asking, can a sole director of a limited company be furloughed for the PAYE salary part of their income only?
Okay. Simon, the government's not been very kind towards directors of companies. The answer to your question is, insofar as a director receives PAYE pay, that is the only element of pay that is potentially recoverable under the furlough scheme. I know a lot of directors got dividend payments. They're not recoverable at all. All you can recover is the PAYE element. And yes, if you furlough the director, that is recoverable. However, this is what the regs say. Work undertaken by a director of a company to fulfill a duty or other obligation arising by or under an act of Parliament relating to the filing of company accounts or provision of other information relating to the administration of the director's company is the only work that you are permitted to do. So if you're doing your annual accounts, or if it's some other statutory function you are fulfilling, you can do it, but that apart, you can't do anything. And I'm not sure if you're running your own company and it's a small company, I'm not sure whether you can fit within that exception of doing nothing, such as to be eligible. But if you can, then yes, you can recover it, the PAYE element of the furlough.
Okay, thank you, Robert. Can we go to Deborah's question, please, which is, can you make anyone redundant whilst they're on furlough?
Yes. There is no reason why you can't do that. An individual or individuals are being furloughed. Effectively, they're receiving a sum from the government. But if you reach the view that, frankly, there's no job for them, whether we wait now or in a week or two's time, there's no job, they are redundant, then yes, you can take them down a redundancy route. It is the normal redundancy rules that apply. So depending on numbers, there may have to be collective consultation, but that apart, there would need to be individual consultation with the employee at risk, a decision informing them that they are redundant with a right of appeal, and they would be entitled to their redundancy pay and, of course, their notice pay. You would not be able to recover, in my view, their notice pay under the furlough provisions, because they are now subject to notice, and so you would have to pay them their full pay for their notice period.
Thank you. I think we are just about there. If I may, I've got one question of my own, and that's concerning valuable teams who may be furloughed, but where an employer wishes to maintain some sort of contact, which obviously must not, I understand, can't amount to work, but just in terms of keeping people who are home-based feeling involved in things. Do you have any guidance around that?
The regulations are quite clear. They can't do any work for you whilst they are furloughed. So members of staff are not permitted to do any work. They must cease all work in relation to their employment. However, they are entitled to do volunteering work, and they are entitled to be trained whilst on furlough. Now, for me, all of the guidance talks about people doing work for the benefit of the company. It talks in terms of trying to generate remuneration for the company, work for the benefit of the company. If all the company is doing is keeping in touch with the employee, I do not consider that to be a breach of the furlough regulations at all. In fact, I would go so far as to say you are failing in your responsibilities to your employees if you don't keep in touch with them. Just to make them feel, and it's important to make them feel that they're still part of the company, they're still, you hope to bring them back in the fullness of time, and that they're still valued. So I think the sort of keeping in touch ethos is not going to be a breach of the furlough regulations at all, as long as you're clear that that's what you're doing. If, however, you're trying to get them to do something which is work in relation to their employment, then you can't do that. But this isn't work in relation to their employment. This is keeping in touch with them to provide reassurance and to check that their health and welfare is okay. And I don't think that breaches anything. Quite the reverse. I think you should be doing that.
Brilliant. Okay, Robert, I've just checked our chat box. I think we have answered all of the questions. So I think let's draw stumps there. To those of you who are listening and have participated, thank you very, very much indeed for joining NE1's first webinar. Seems to have gone all right, certainly from my point of view, so really, really appreciate it. Robert, you're an old hand at this. But thank you very, very much indeed. We really, all of us, very much appreciate your expertise and guidance on this. So finally, to say thank you on all of our behalves to Robert and Samuel Phillips. It's been a really complex, it is a complex area, this. So do please consider taking professional advice. There's a lot at stake and nobody wants to get it wrong. Watch out for more of them. I think we've cut our teeth on this one, and more to follow. So thank you all very much indeed, and have a great weekend.
Yeah, and it's goodbye from me too.
Thanks, Robert.
Okay, cheers now. Oops, and I'm leaving the meeting.